Today is Wednesday, December 30th, 2020. Welcome to another episode of Legal Briefs. Hi, my name is Wes Austin. I'm a lawyer trying to keep you updated on all the latest legal news. Next Wednesday is January 6th. There will be a joint session of Congress to count the votes to see who the new president is going to be. Can someone object? And what can happen if someone does object? That is what we'll be talking about today, all right? Now, in this joint session of Congress, Vice President Pence will be presiding. They receive the slates of electors, they count the votes, and if one of the candidates receives 270 votes or more, then they're declared the winner, all right? Now, that comes from the 12th Amendment of the Constitution. Now, according to the numbers I've seen, former Vice President Joe Biden currently has 306 electoral votes. President Donald Trump has 232 electoral votes. You only need 270 votes to win, so that would seem Joe Biden clearly has enough votes to win. Now, here's the thing that people are talking about. You can have people that object to the votes. You can actually have those votes thrown out. Now, if that happens, we're going to talk about that a little bit later. But if that were to happen, theoretically, it could happen, just theory, okay? But theoretically, if that were to happen, this other part of the 12th Amendment kicks in, and let's read some of that language now. If no such person have such majority, the House of Representatives shall choose immediately by ballot the president. But in choosing the president, the votes shall be taken by states, the representation from each state having one vote. Okay, so according to the 12th Amendment, if neither person has 270 electoral votes, neither of them have the majority, then the House of Representatives would elect the president, and they would do that where each state gets one vote, okay? So I think in theory, what some people are thinking is that if enough states' votes are disqualified by objections, then perhaps the number of electoral votes that Joe Biden has would dip below 270, and then this alternative clause in the 12th Amendment would kick in, okay? And I believe, from what I've read right now, I think at least 26 states have Republican legislatures, and so they're thinking if they can get to that alternative clause, then President Donald Trump would be elected. Now, in order for that part of the 12th Amendment to kick in, where you have one state getting one vote, you have to have an objection by members of Congress. And you can do this under a 130-year-old law called the Electoral Count Act. And you have to have an objection from both a member of the House and a member of the Senate in writing. Okay, now let's look at some of the language from this Electoral Count Act that enables this to happen, okay? The President of the Senate shall call for objections, if any. Every objection shall be made in writing, and shall state clearly and concisely and without argument the ground thereof, and shall be signed by at least one senator and one member of the House of Representatives. So, before you can get this even started, you have to have an objection from someone in the House and the Senate in writing. Now, I understand that there are people from the House who said they are going to object in writing. I haven't read that anyone from the Senate is currently willing to object in writing. I think there were a few that said they would think about it. So if you have an objection that qualifies, like we talked about, then what happens is the joint session is suspended and you have the two chambers meet separately. So you have the House meet separately from the Senate, and they both will debate the issue, talk about it. I believe the time limit is 2 hours, and then they will take a vote. And you have to have both the House and the Senate have a simple majority. They both have to agree to sustain the objection for that objection to be sustained. So if you have one of those chambers not agreeing to that, it stands as is and the objection is thrown out. Now let's look at the language from the statute that this is based on. So this is the language that supports what we're talking about, that both chambers must support this objection or otherwise it's just going to fall through. Let's look at that language. But the two houses concurrently may reject the vote or votes when they agree that such vote or votes have not been so regularly given by electors whose appointment has been so certified. Okay? So you have to have both chambers agree if you want to have that objection sustained and possibly those electoral votes thrown out. All right, now has this procedure ever been invoked before? Yes, it has, actually twice. In 1969, there was an objection in writing from both someone from the House and Senate. They separated, debated, and they ended up keeping the electoral votes as cast by the slate of electors. And then in 2005, it happened again, where you had an objection in writing from both someone in the House and the Senate. They retired to the different chambers. They came back, and again, they upheld the electors as cast by the slate of electors before the objection. So it's happened twice, and both times they kept the votes as they were given by the slate of electors. So if we see this kind of objection where the joint session is suspended and you have the House and Senate separate, I think you'll see the members of the House or Senate using the same kinds of arguments or reasoning that you've seen in a lot of these election law cases that have been going on across the country. So how long can this go on? Well, luckily, I think we are limited to no more than 2 hours for this debate, and each person can't talk for more than 5 minutes. All right, let's look at the language from the statute about this. Each senator and representative may speak to such objection or question 5 minutes, and not more than once. But after such debate shall have lasted 2 hours, it shall be the duty of the presiding officer of each house to put the main question without further debate. So if we do have an objection which causes the two chambers to separate and argue, you have this debate for 2 hours in each one, I think the chances are very, very low that you're going to have either chamber actually support the objection. And remember, you have to have both of them support it in order to throw out the votes from the slate of electors. So, the House controlled by Democrats, I think the chances are, almost zero that they would support the objection. And the Senate Majority Leader, Mitch McConnell, he's telling his caucus not to support anything like this. So I feel like the odds are really slim that you would have both the House and the Senate support an objection. So I think the original slate of electors that were sent and they're going to be counted, those will continue to be counted. Thanks for watching. We'll see you next week.